Hello and welcome to our webinar, The Do's and Don'ts of Conducting Workplace Investigations. My name is Linda Duffy, President of Ethos Human Capital Solutions. I work with business owners and executives to provide strategic human resources direction, develop leadership talent, and increase organizational effectiveness. I'm going to be serving actually two roles today as a speaker and your moderator. Unfortunately, Julie Dorr, our usual moderator, is unable to be with us today. Our presentation will last approximately 40 minutes with the remaining time available for your questions. If during the presentation you have any questions, feel free to type them into the designated area to the right, and we will answer them at the end of the webinar during our Q&A. You will also notice in your dashboard that we have uploaded a copy of the slides for today's presentation. Feel free to download those or print them out and take notes as we go. I'm also going to apologize in advance for any technical errors because I'm not used to doing this, but hopefully we will get through this together. Before we get started, please note that this webinar and all of the accompanying materials are protected by copyright and that the entire conference is being recorded. This presentation provides general information only and does not constitute legal advice. We recommend that you consult with legal counsel to address your specific situation. And of course, we always recommend Marla Merhab Robinson. So let me introduce Marla now. Marla is with the law firm of Merhab Robinson, Jackson & Clarkson, where she is managing partner and head of the firm's transactional department. She primarily practices in the areas of corporate, mergers and acquisitions, real estate, finance, and of course, employment law. And with that, let's get started. That's my smiling face there. So today's agenda is really to walk through all the do's and don'ts of conducting workplace investigations. We're going to be touching on what the EEOC guidelines are for that and sort of using that as our outline for today because it talks about when to investigate, steps for conducting an investigation, assessing credibility, which can come into play, especially in he said, she said situations, what to do after the investigation, and then confidentiality, some steps you can take in terms of remedial action and what your requirements are there, and then some final thoughts. So the EEOC guidelines, which I'm sure are very similar to California's guidelines, require these sort of 8 things. So promptness, meaning a company's response to the harassment allegations or whatever allegations must be diligent and timely. So that means it should be launched immediately if possible and concluded as quickly as possible. And of course, that's all going to be dependent on different factors, right? Where the parties are located, how much access you have to them, how much evidence has to be collected and reviewed, those type of things. Impartiality is critical. The goal is to have a neutral investigation, of course. So you want to make sure that the people doing the investigation is going to look just for the relevant facts and make sure that they don't have any sort of agenda in what they're doing. Confidentiality is a big issue, and of course we always want to protect the confidentiality of the allegations to the extent possible. And Marla's going to address this later, and making sure everyone knows not to promise absolute confidentiality because that's never possible. So we always just say, it's on a need-to-know basis. Training is referring to the person who conducts the investigation and making sure that they are well trained in the skills that are required for interviewing witnesses and evaluating credibility. Thoroughness, of course, is important. As we mentioned, there should be a mechanism for a prompt, thorough, and impartial investigation into any sort of allegations. Number 6, questioning is that the investigator should ask relevant, open-ended, and non-leading questions in an effort to elicit facts and not really going after looking for opinions or trying to draw conclusions or asking questions that fit what you believe to be true before you actually hear everybody out. Of course, determining credibility can come into play, especially as I mentioned a second ago, he said, she said situations. If there aren't facts, there aren't witnesses, and you just got 2 sides of the story, then of course you're going to have to make a determination on who is more credible. And then finally, of course, you're going to make a determination once all the evidence is in, and we'll talk about that as well. So one of the critical things to know about conducting investigations is that you must investigate upon actual or constructive notice. So this includes things like anonymous tips or rumors, hearsay, third-party statements. It can be anything like happened to one of our clients this past week. We got an unemployment insurance claim after the employee had been fired for performance-related issues, and it said it had an allegation that she had been fired for requesting FMLA, which is protected. And so, of course, we have to go through and say, okay, do we need to have an investigation on this? And if so, we need to get it started. Even though that employee no longer works with that company, it is an allegation. And so you have to take that into consideration. If the employer has constructive notice, that means the conduct is so pervasive the employer should have known it was going on. It's not okay to say, well, nobody came forward and actually filed a complaint. So anytime you have notice of the complaint, even if it's post-termination, even if it's an anonymous note slipped under a door and you don't know who even brought it, you still must investigate and document the fact that you didn't have, someone to talk to because you didn't know who had slipped the note on your door, whatever it is. The other thing to keep in mind is you must investigate even when the person doing the accusing says, but don't do anything. I just want you to know about this. And I'm sure Marla will touch on this later. A lot of times it's just that they fear retaliation, but it's not okay. And we've had that situation happen where somebody comes forward and says, I just want to tell you something that's going on and make you aware of it, but I don't want you to do anything about it. And of course, what happens later? Right now they may not bring a complaint, but later on, not only do they bring the complaint, but then they allege the company had knowledge and you didn't do anything about it. So we want to make sure that it's super important that no matter how the allegation gets to you, whether it's verbal, in writing, anonymous note, post-termination, brought in a complaint, whatever it is, your duty is to conduct the investigation. As I mentioned a few minutes ago, promptness of investigation is really important. So it needs to commence as soon as possible. You don't wait until someone says, well, I'm going to sue you for this. If they tell you that there is some sort of allegation, you need to take the steps to move forward and actually conduct the investigation. Now, it could again be delayed for different reasons. It could be that the person bringing the complaint has legal counsel and you're trying to work through them to get to the former employee or something like that, and it may take a while. But as long as you can document they're taking steps in that direction, that's what's most important. You, of course, want to choose the right investigator. What's critical is the investigation must be an impartial one. So you want to make sure that the investigator doesn't have any, for example, supervisory authority over the, that the wrongdoer doesn't supervise the investigator and the investigator doesn't supervise the wrongdoer, for example. You want to make sure that there's no direct reporting relationship or even anything that could hint to the investigator having their own bias. So it needs to be performed by someone who has no stake in the outcome, wasn't involved in the incidents, isn't a witness, really has just no dog in the fight, so to speak. Typically that's somebody from the Human Resources Department or some other neutral entity. It of course can be somebody from outside the company. Usually that's a private investigator or an attorney. And you just want to make sure that whoever you choose to be an investigator is well trained in that subject matter under investigation. Is it discrimination, sexual harassment, whatever that could be. You want to make sure that you're doing whatever you can to protect the person bringing the complaint during the investigation. So let's say let's take a sexual harassment situation. A woman comes forward and she says, I'm being harassed by my boss or by that other employee or whoever it could be. You want to take appropriate steps to avoid contact between those two individuals during that period of time. So it could be rescheduling the person that's accused to a different shift, to a different department. You could temporarily place them on a paid leave, an administrative leave, send them home for a few days while you conduct the investigation. You want to make sure that you're not penalizing the person bringing the complaint in any way. Sometimes what we'll do is ask the person bringing the complaint, what would you like to do while we're investigating? They may say it's fine, it's not a situation that's so egregious that I have to be, kept at a distance from that other person, or it could be they're so scared to even go back in that department near the person. So just have that conversation and document whatever is said. Okay, so let's talk about conducting the investigation, because this is really the meat and the potatoes of it, and this is what we're going to spend a lot of time on. These are sort of the steps, more or less in order of what we do when we go in to do an investigation. We're always going to start by talking to the person that is bringing the complaint first. So we're going to interview the accuser. We're also going to then interview any witnesses. So when we're talking to the accuser, we're going to say, who else has knowledge of this? Who saw something? Who was involved in this? Anything. So you want to go ahead and interview those witnesses to if there was an event, let's say. If it's something that's just a perpetual thing that goes on, you might say, well, there anybody else that have knowledge of it? Maybe they didn't witness it, but maybe you told them, or you heard that the person you're accusing told some other people. Who has knowledge of the event? Of course, we're going to interview the person that's accused. And I always tell people when we go out to do anti-harassment training in particular, you have to stay calm if you're being accused. It's really tough when somebody is saying that you did something and you want to defend yourself, but trust the process, because no one's going to make a determination. This would be a big don't. No one should be making a determination about what happened without talking to the accused. Of course, you want to review relevant documents or evidence, let's call it, because it could be any different type of things. It could be payroll records, it could be photographs, it could be voicemail, text messages, emails, personnel files, whatever. Re-interview people as needed, because sometimes you may start by talking to the person bringing the complaint, and then by the time you talk to some other people or look at some documents, you need to circle back with that person or circle back with witnesses, re-interview them as needed. You're going to write an investigation report, and then you are going to share the results with the accuser and accused. So one of the requirements is thoroughness of investigation. As I just mentioned, you want to get the complete story from the person bringing the complaint before interviewing anybody else. You also want to make sure that you're looking at all of the relevant documents, but again, let's say evidence, because it could be related to the person bringing the complaint. It could be related to the accused. It could be if it was a discrimination, or let's say it's a complaint brought for discrimination like pay inequity. You may actually have to interview other employees that aren't a party to the direct complaint, but maybe they are in a comparable situation, so you also need to look at their employee files. You just never know where it's going to take you, so you want to stay open and make sure that you're being as thorough as possible, and spend as much time as needed to do it, of course being quick to wrap it up as well. So here are a couple of just notes on what not to do. Is you want to make sure you're not violating any sort of privacy rights, and usually that comes up because people or say, well, like let's take this situation that I just mentioned where we let somebody go and then she alleges, oh, it's because I requested FMLE. Well, the point is not what the medical diagnosis is. The point is whether or not she made a request and whether or not the client ignored it or took some action based on that. But it would not be appropriate to say, well, we don't know if you're entitled to FMLA, tell us what's going on, tell us what your diagnosis is, something like that. Usually what we suggest is don't review the personnel files prior to the investigation. What you want to do is stay as neutral as possible, and you don't know what's going to show up in the personnel files. It could be important later. There could be documents or whatever, but don't wait until after you've talked to the witnesses before you go and take a look at the personnel file, so it's not causing you to be biased in any way while you're going through that. Okay, whom to interview? We've already referenced this. You want to interview, of course, witnesses that may have been involved, that may have been told about anything. You also may have to interview former employees or third parties, customers, students if it's in a teaching situation, client witnesses, and you're going to have to give some thought to balancing how thorough do I want to be, how relevant is the information they may have, with how is this going to impact our business, right? You want to do the right thing for sure, but you don't need to bring in everybody if it's unnecessary to the investigation. You just want to make sure that you're taking a look at that critically. Is this person important? And you're making the decision based on the needs of the investigation and the thoroughness and not the business decisions. And then, as I mentioned, you're always going to circle back and re-interview witnesses if something may have come up during the first round, or as secondary interviews go on, it's something you didn't handle in that first conversation with people. Really important when you're conducting your thorough and complete interviews that you're asking open-ended questions. So what I mean by that is something like, okay, now that you've heard the general nature of the complaint, what's your response, right? Or what can you add that will help us resolve this situation? You want to avoid any sort of leading questions like, well, isn't it true that John started acting differently toward his female employees shortly after he got divorced, right? You don't want to sort of plant facts in there as well. You also want to elicit facts as opposed to opinions or supposition. A lot of times people attach significance to things, and that's an opinion, or it's based on their own history or baggage or things that have happened before. And really what you're trying to stay focused on are the facts of what exactly happened. And then, of course, we always suggest interviewing face-to-face whenever possible. I think it's really critical, especially if later on down the road you're going to be asked to render some opinion on credibility. And again, that depends on if there aren't enough witnesses or any evidence to support the person bringing the complaint. You may be in that situation. Well, to me, being able to face and interview people face-to-face really helps me with reading their body language. Are they able to make eye contact with you, or are are they really defensive, or they're trying to be evasive and it's taking you forever to draw out information. It has happened, of course, depending on, there might be a witness that's out of town now or out of state. In an effort to get it done promptly, you may want to interview them by phone. Of course, today with technology, you can do face-to-face, Skype, over an iPhone, whatever it is that you want to do. So just take that into consideration. So here are some sort of steps that I would recommend. Is first of all, put the witness at ease. People are really, really concerned usually and very nervous. They get called into an investigation. So, you don't need the bright light, interrogation tactics. It's really, I usually just call people in, just sit them down and say, how's it going today? And, do you know why you're here? Have you had any conversations with anybody? Because usually at that point, if it's the person bringing the complaint, they know why they're there. If the person being accused may have no clue whatsoever or may have heard rumors, witnesses may know something, may not. So put them at ease, find out if they even know why they're there. I usually assure every witness that the company just wants honesty. Like, there's no judgment here. We're just trying to find the truth. We're trying to figure out what's going on. We're trying to resolve a situation. And also reassure them that the company's not going to tolerate retaliation. I probably say that to people 5 or 6 times during the course of those conversations. Like, you don't have to fear retaliation. The company's not going to take any action against you for participating or for bringing the complaint or for being accused or whatever. There's not going to be retaliation. Explain the process to them. Tell them exactly what's going to happen. So I always say, look, I'm going to start by talking to you. If you're the person bringing the complaint, we're going to get the set of facts. You're going to tell me your story, what's going on. I'm going to ask you about witnesses. I'm going to ask, what evidence do you have to support the allegations you're bringing? I'm going to talk to those. I'm going to review the evidence, and then we're going to write a report, and we will circle back with you. So that's what I usually say, just to explain the process to them, and then again, continue to reassure them. I'm always going to start with my broad open-ended questions, and then I'm going to pinpoint. And what I usually do to get the chronology of events and to sort of lock them into their story, whatever it is if I'm interviewing the person bringing the complaint, I'm going to say, okay, so tell me what's going on. I heard you came forward and brought a complaint. What's going on? So I get them, and I'll say, okay, so what's the first time that this happened, if there's a pattern of behavior? And they'll say, oh, it was January 1st. And I say, okay, so January 1st this happened. What happened next? Then they tell me the next part of the story. I said, okay, so January 1st this happened, and then on January 16th this happened. What happened next? And every time I go back, I repeat the same thing over and over again to sort of lock in the timeline. And I take really detailed notes, and there's a lot of times where all of a sudden somebody will say something. I'll say, well, wait a second. I thought January 1st this happened, then January 15th this happened, and then February 1st this happened, and now you're telling me this happened January 4th? So tell me again how this goes. So we'll go back over it as many times as I need to in order to make sure I have the chronology correct. Excuse me. Of course, ask one question at a time. Try to be really simple in the questions. When you ask compound questions, it can get confusing to people. So you want to be, as straightforward as possible, and you want to make sure that you're writing as much stuff down as possible. And again, to get the facts out, ask all of those reporter questions, who was involved, what happened, where did it happen, when did it happen, how did things happen? All of those reporter type questions can serve you really well when you're conducting the interviews. Few other thoughts: document the employee's actual words. And I think this is really critical. A lot of times when I get called in, and whether it's a business owner, HR person, whoever, will call me and say, so-and-so says it's a hostile work environment. Okay, well, hostile work environment is a legal term. So I'll go in, I'll sit down with the person, and you have to keep in mind, a lot of, sexual harassment, discrimination, type of complaints, sort of one of the critical elements is that the person is being singled out based on some sort of protected category. So I want to document the employee's actual words. What did that boss say to you when they talked to you? Because words can mean different things to different people, and I want to make sure I'm using the employee's actual words. I'm also listening to see, did they say anything that could give rise to a protected category, right? So I was working with a company not too long ago where an exec admin was having problems with her boss, and she said that he had said things like, oh, I'm a slave driver. So I understood the context when I talked to him of what he meant. He just meant this isn't an 8 to 5 type of job and I expect you to work longer hours. It was a very unfortunate choice of words. But to her, she happens to be from Africa. So to her, it had completely different meaning, right? So you want to make sure that you're understanding and writing down exactly what the employee says and exactly what the person being accused says. And again, if you have any witnesses to that. So again, focus on gathering information, but not drawing conclusions, not putting your own spin on things. Slave driver as a phrase meant something very significant to her. It could mean something different to me, different to you. Doesn't matter. So you want to make sure that you're just gathering information and not putting your own spin on it. And then a good practice after you're, toward the end of an interview with somebody is to ask, do you have any other information you want to add, or, are there any other questions that I didn't ask that maybe you think I should have asked, right? Just open it up to say, what else do you know that I should know, basically. Okay, after you've completed the interviews, you may have to make a credibility assessment. Because if there are conflicting versions of events, if it's a he said, she said, anything like that, then the person doing the investigation must weigh credibility of the witnesses. Okay, so here are some of the factors to consider. Does the story even make sense? Okay, I've been in situations where I'm working with clients where it has so many conflicts inherent in the story, just doesn't even make sense, right? And I'm like, how can this person even reconcile this in their own mind? So you want to consider that. You want to consider the demeanor, and that's why I think body language and face-to-face is really important. People can be nervous in investigation, whether they're making the accusation, they're a witness, or they're the person being accused. So of course you want to factor that in. But if the person is excessively nervous or fidgety, can't make eye contact with you, it could be possibly because they're not telling you the truth. How forthcoming was the person? Did they just come in and they act like, okay, just tell me, ask me the questions and I'm happy to help? Or, did you have to drag it out of them step by step? Does the person have a motive to lie? Anybody? Do they have a hidden agenda here? If the person bringing the accusation is successful in the accusation, does it benefit them in some way, right? Do they all of a sudden get a promotion? It could be anything. Does the person obviously being accused have a motivation to lie? Maybe they're afraid of losing their job. So it can come up in all different ways. Of course, we're going to go through, is there any corroborative evidence? Is there anything that we can point to that's going to back up the person bringing the accusation or any of the witnesses or the person being accused? And then finally, do they have a past record of this kind of conduct, or do they have a past record of maybe not being truthful? So you want to take in all of those considerations when you are making a decision about how credible somebody is. Hopefully, you're going to have some sort of corroboration, but that doesn't always take place. After you do the interviews, you've made your assessment of the credibility, you're going to reach some sort of determination. I think what's really critical out here is that you need to be careful about drawing any conclusions whether the conduct was legal or illegal. Usually what attorneys like, but maybe Marla can weigh on this later, is they don't want a report that says harassment occurred or harassment didn't occur as much as they want whether or not the conduct or behavior in question was appropriate or inappropriate, because they don't want to get pigeonholed later on down the road if this goes to trial or anything like that. So you just want to be careful about the language that you're going to put in a written report. So write the report, you're going to indicate things like the behavior was inappropriate, or it could have been behavior was a violation of company policy, things like that, as opposed to this person broke the law, okay? You're not in a place to make a decision about the legal aspects of it. Obviously, the determination is going to be made by the investigator or a person, a management official who reviews the investigator's report. A lot of times what we do as a third party, we're going to write the investigation report to, whoever our contact is. That could be the Human Resource Department or the CEO or the business owner. It could be that we're doing this, so it's privileged, and it may be going back to an attorney that has sent us in to do this, okay? Ultimately, the parties need to be informed of the determination, and usually what we suggest is you write a memo to the person who brought the accusation and to the person who was accused. And they can be very similar, and you don't have to go into a great level of detail, but you're going to thank them for their participation, reiterate that you take it very seriously, that that you interviewed people and you looked at the evidence, and that based on that you've determined that inappropriate conduct did or did not occur, that type of thing. And then you're going to take all reasonable steps to make sure that that does not happen again going forward if there was in fact something. You don't have to spell out for the person bringing the accusation exactly what you're going to do. You can just say that you're taking the appropriate steps. All right, so investigation report, I just referenced that a lot. Remember to consider privilege, whether or not you're doing this subject to, a request by an attorney. You might want to get your legal counsel involved early on in this process. Most attorneys, if they're an attorney for you as a client, don't want to do the investigation themselves because they don't want to be called as a witness, but you can bring in an outside attorney to do it. You want to describe the chronology, list everybody, this is in the main report, that you interviewed, the documents reviewed, attach any relevant records, and again, you're going to make factual conclusions, and then you're also going to make some recommendations on what you think should happen going forward to take care of the situation. And with that, I am going to turn it over to Marla to take it home from here.
Thank you, Linda. That was awesome as always, and I just have to point out, this is one of those areas that the HR directors and other personnel that are deemed responsible for investigations, other than the professionals that are outside, licensed investigators and attorneys, really don't like this job, but it's so critical and it's so important. And just to backtrack a little bit about why we are doing this is because we have law from our courts that says performing proper workplace investigations is one of the necessary reasonable steps that we're required as employers to do. We're required to do this to prevent discrimination, harassment, or retaliation. And just as a reminder, on the heels of all the national news about Bill O'Reilly, we are not just talking about sexual harassment investigations, but all discrimination and retaliation as well as harassment. So some of what I'm going to say is going to be a little bit repetitive of what Linda's done, but it's worth repeating. So I apologize in advance, but hope that it helps as well. So about proper documentation, she just finished talking about the end of the documentation, the investigative report, but before that, there is other documentation going on during the investigative process. You're going to document the complaint and obviously the response as well. You can ask the complainant to put the claims in a statement of what happened in writing. I prefer this. I really like this. But many times they won't, and you can't force them. So you just ask nicely for them to do it. It's a great way to start. Gives you kind of a roadmap of where the questions go. Same thing with the accused, you can ask for a response in writing first before you start the dialogue that Linda did such a great job explaining. And it gives you that opportunity, again, to prepare a written plan of where you're going to go, who you're going to talk to, what witnesses. Oftentimes when you talk to witnesses, you then get another witness, or as Linda pointed out, sometimes third parties that are outside of the employer's space, but might be vendors or clients, that will require you to go back, and then that requires you to go back to the accuser and the accused as well. With respect to tape recording, just keep in mind that California law requires you to ask permission to tape someone, and that should be on the tape recording with them giving permission. Very oftentimes they'll say no. Don't be shocked, don't be worried, don't be concerned. Just note it that it was asked and they said no. Do not tape record someone who does not give you permission. It is a criminal act, and it comes with a penalty of a couple $1,000s, and also you may end up getting that information excluded in trial when you really need it. So also, it sometimes tends to result in a chilling effect where the witness or the accuser or the accused won't be forthright, and goes to that issue Linda explained earlier about making them at ease. And if that's going to not make them at ease, then don't do it. Some people actually prefer it because then we can have a dialogue eyeball to eyeball, and I don't have to be looking down at my notepad taking notes or my laptop taking typewritten notes. And then, of course, the written report. Linda mentioned it. I'm going to hammer it home because it actually happened several years ago where I had a client who conducted an investigation without any assistance from counsel and without an outside PI, and there was an internal email from one of the management team to another member of the management team that said, we discriminated against this gal, we should pay her some money. Now that's going to be a very large piece of evidence if it ever goes to trial in front of a judge or a jury, and it's going to underline it, and the opposing counsel is going to say, look, their own management team said they discriminated against. So we do very strongly recommend you not use any legal terms. When I train one-on-one or in groups on investigations and writing these reports, I tell my clients all the time, do not make a legal conclusion. You are not a lawyer, you're not a judge, you're not a jury, and only a judge or jury can actually ever determine whether we discriminated against this employee, not even the lawyers. The lawyers only give opinions. So an actual conclusion that it occurred can only come from a judge or a jury. You can only say whether there was inappropriate conduct, as Linda pointed out, that's a term we really like, or a violation of company policy, and use those terms. And then if it ever has to go to trial, unfortunately, then the judge or the jury can make the legal determination of whether or not it was illegal activity. So very strongly encourage you, when you do write the reports, to have them written by counsel, to have the language looked at. Make sure your notes on all of the investigation are as detailed as possible. Not all of the notes need to get into the report, and we can talk about the attorney-client privilege if we have extra time during the questions. So confidentiality, Linda touched on this as well. You don't want to guarantee complete confidentiality because you can't. When someone comes to you with a complaint, you need to be able to speak to the accused, you need to be able to speak to the witnesses. You can ask all parties involved to keep everything confidential. You can say that information or records about the allegations will only be shared and should only be shared on a need-to-know basis, especially when there are people involved that might be in a supervisory capacity and the fear of retaliation is there. A conflict arises if the employee informs a supervisor about alleged wrongdoing but asks him or her to keep the matter confidential and take no action. All supervisors should be trained to know that that is not acceptable, that if an employee comes to you and says, I really don't want you to tell anybody this, but you're my friend, I want you to know this happened, or I witnessed this, or this happened to me. The response by all supervisors and everybody at every level actually should be, I need to report it to HR, I need to take it to whoever is handling the HR functions. By law, the company must engage, as I said earlier, in the investigation. It's what the courts have found is one of our required steps to prevent discrimination, harassment, and retaliation as required under both federal and state law. So that needs to be made very clear because this is very common. It happens often I get calls from clients and they'll tell me that an employee has come in and complained and said, don't do anything, I just want you to be aware of it. So the response must always be, I don't have a choice. By law, I have to do this. If you take it out of the blame of the employer and say, the law requires me to do this, most employees will back down and they understand it. But you can never guarantee complete confidentiality because you can't have an effective investigation without revealing that certain information, as I said earlier. Continuing, you want to advise all the witnesses. You can do it in writing or you can do it orally, whichever you prefer. Just make notes that you've done it to keep what you're inquiring about confidential. You have to be very careful about not having a company-wide blanket policy of confidentiality with respect to investigations. We actually have one case called Banner Estrella. If anybody's interested in the site, they can shoot me an email, where the court said, no, this was a blanket approach. It was too broad, and it ran afoul of the NLRA, the National Labor Relations Act, which, for those of you who don't know, allows employees to discuss working conditions. And the type of behavior that was at issue was a working condition. It was possible that it fell under that. The difference in Banner was that they actually had a written confidentiality agreement that just prohibited everything. It just made everything confidential. And the court said, no, we got to look at this on a case-by-case basis. And in most cases, when you look at it on a case-by-case basis, the type of investigation you're doing, it should be something that should be held confidential by the company and requested of the employees to keep it confidential, but not a blanket policy of confidentiality. You want to document why confidentiality directives were given. And usually the why there, the reason, is the integrity of the investigation. You don't want witnesses to be compromised. You don't want them, you all have heard of the game telephone, when you hear it from somebody else who heard it from somebody else who heard it from somebody else, the stories change, the facts change. So that's one of the whys confidentiality directives are given. And then the second why, of course, is retaliation. We're supposed to be doing everything we can, taking reasonable steps to prevent retaliation. So we don't want the accuser, by supervisors, by anyone, to be retaliated against. We have at least one case in California that says there's a separate cause of action for failure to prevent retaliation. That hasn't really made its way up to the California Supreme Court yet, but we'll see where it goes. So you want to take immediate and appropriate remedial action. Linda touched on this as well. Remedial measures should be designed to stop the wrongdoing and correct its effects on the employees. Also send a message to the rest of the company that we do not tolerate this type of wrongdoing or inappropriate conduct. We want to take measures to inform both parties, and it sends a message that it's serious, but it also needs to be appropriate. So let's go to the next one and talk about what are some of the ways to make sure that it's appropriate. We need to balance the concerns. We have the concern that the employer could be found liable if wrongdoing doesn't stop. We certainly want to do that. I'd say the biggest concern is we want to protect our employees from illegal conduct, right? We want to protect our employees from harassment. We want to protect them from discrimination. We want to protect them from retaliation. We have a concern that if we have overly punitive measures, we might have claims such as wrongful discharge. So if the accused is terminated because of the investigation and the conclusion, the accused may say, nope, I'm going to file for wrongful termination. I was wrongfully terminated. This wasn't the real reason I was terminated. I was terminated for some other reason. So just by way of example, if it's necessary to separate the parties, Linda talked about this a little bit, then we should ask the accuser first, what would you prefer be done? And if there's no preference, the accused of the wrongdoing, if it's found that the wrongdoing has occurred, should be moved. Another example of, we've got here proportionality that Linda spoke about. If the harassment was minor, such as a small number of off-color remarks, and the person has no prior history, or maybe it's bringing an inappropriate picture, of nudity or a Facebook post to another employee. This is a common one that's occurring now. And sometimes counseling and an oral warning may be all that's necessary. Here are some examples of different types of measures to stop the wrongdoing or inappropriate conduct and prevent recurrence. There's oral or written warning or reprimand. I would recommend that if you do an oral warning that you still make a note. The oral warning was given on April 21st, 2017 by whoever gave it, witnessed by whoever, and also stick that note. Even though it's only oral, that's less offensive to the employee who's receiving the warning, but it's still an oral warning that you want to know that you made, so you need to get that into the employee's personnel file. Another example is transfer or reassignment. Sometimes that's not possible depending on the size of the employer. Demotion is an example. Reduction of wages. Suspension. Very often we do suspension also, by the way, during the investigative process, especially if it's particularly egregious behavior. Sometimes it's fear for personal safety. Of course, discharge is always available. Training or counseling of wrongdoing. I want to talk a little bit about this because there's different types of training and counseling. We often recommend private training because of the type of alleged inappropriate conduct. It may be that this isn't something we want to train the entire workforce on. It may be so personal that it needs to be just that one person. Other times it's such a common form of inappropriate conduct. We're going to go through training with everybody. We're not going to call out the person who is in trouble, but it sends a message to everybody again that this is not acceptable behavior. And then monitoring, obviously, continuing. Every time inappropriate conduct has been found, the accused should be told, if they're not terminated, that if it happens again, they're subject to further discipline up to and including termination. Examples of measures to correct the effects of wrongdoing. Restoration of leave taken because of the wrongdoing. If you have an employee who felt that they were being discriminated or harassed and took leave of absence because of it, it was so egregious they couldn't stay at work, you could give that leave of time back. Expungement of negative evaluations. It may have been may have arisen from the wrongdoing, may have been a form of a retaliation. Reinstatement. Someone was terminated. Apology by the wrongdoer. This is a huge one. Very often, that's all the other employee, the accused, is looking for, is an apology. They want their dignity back. They want respect back. Everybody wants to be respected in the workplace, and they just want the person to say they're sorry, and they want somebody else to know that they said they're sorry. So this is a very common measure to correct. Monitoring treatment of employees to ensure that it's not subject to retaliation. Again, the law is very clear. We have to take all steps to prevent retaliation. So as Linda said, from the beginning of the investigation all the way through, we are telling everyone, the accused, the accuser, all the witnesses, the supervisors, nobody will be retaliated against for bringing a claim of harassment, discrimination, or a claim of even retaliation. Correction of any other harm caused. There's compensation for losses if there was lost commissions, things like that. We can do anything we want to try to correct the effects of wrongdoing. Other preventive and corrective measures. The employer has a greater opportunity to guard against misconduct by supervisors than by workers. We all know that supervisors have strict liability. I'm sure you all know about the mandatory 2-hour training for sexual harassment for supervisors, and expand that to include all forms of discrimination. We've got to screen, train, and monitor our supervisors all the time. We need to let them know that if an employee files an EEOC charge alleging unlawful harassment of any kind, that we have to launch an investigation even if we didn't know about it at the time. Now that we know about it, we've got to do it. And Linda touched on this as well. Once you have any knowledge of a potential discrimination, harassment, or retaliation, whether you believe it occurred or not, but the potential that it did, you need, as a supervisor, to bring it to everyone's attention. And again, I would recommend in your employee handbook that all employees be advised that they should bring it to the attention of HR or the personnel that are designated to enforce HR policies. if there are any areas in the workplace with graffiti, for example, containing racial or sexual epithets, management should obviously eliminate it right away and not wait for a complaint. If you see somebody with a screensaver that's inappropriate and sexual in contact or discriminatory in contact, it should be eliminated right away. Postings on Facebook, if they come to the employer's attention and they're tied to the workplace in some way, again, should be eliminated. That's an area that is growing and is going to cause some concerns, I'm sure. But the bottom line is if you see it, whether you're an employee or a supervisory employee, if you see it, report it. If you hear it, report it. We want to make it clear to all of our employees that management is going to take all steps necessary to prevent this. And again, protection against retaliation, Linda touched on this at the beginning, and I will touch on it again. Just remind all parties involved, again, from the accuser to the accused to the witnesses, that the company has a policy against retaliation. Enforce that. Don't allow it to happen. And take responses to penalize anybody who does try to engage in that behavior. And I will remind everyone on the line that you must have a written anti-harassment, anti-discrimination, and anti-retaliation policy written. It's required as of last year by law. Final thoughts. Defective or inadequate investigations can provide evidence of liability and support punitive damages. So they are very, very important in the context of litigation. And that's why I encourage everyone to get the assistance of someone, whether it's an attorney outside, a private investigator, somebody internally who has investigative experience. Certainly all of you are going to have much more knowledge after today and Linda's great techniques, to be involved and be very careful about the language that you use. Be consistent. Be mindful that some employees are reluctant to complain, and that's why you need to make sure that you have that policy of if you see it, report it. If you hear it, report it. Weigh evidence appropriately. There's a common theme I think you can see running through this, and that's fairness. You need to do everything you can to make it as fair and credible as possible. And remember that the conclusion by the employer may be wrong. Linda's touched on this as well. In your final report, the most important thing is to come to the conclusion, even if the conclusion is I absolutely cannot tell who's lying, I can't tell what's the truth and what isn't, or your conclusion is this person did not engage in inappropriate conduct. I believe the accuser is stating this because the accuser's been consistently reprimanded for it being bad performance, not making sales, and so she's coming after her supervisor, or he's coming after his supervisor. The conclusion may be wrong. It may have in fact occurred. It doesn't matter. What matters is that you conducted the investigation as required by law, and that you conducted it in good faith, as we were just talking about, and that you came to a conclusion, and then whatever the conclusion was, you took the reasonable steps necessary based on the conclusion to, again, prevent discrimination, harassment, and retaliation. And with that, I will turn it back over to Linda.
Thank you so much, Marla. That was great. And I know that was a ton of information we tried to cram into about 40 minutes. But thank you so much. That concludes the presentation portion of our webinar, and so now we'd like to spend our remaining few minutes answering your questions. Just a reminder that over on the dashboard, for most people that's going to be on your right, you can submit your questions right now by accessing the question area on your screen. Just type in the question, hit send, and then I will read as many of these out as we have time to hear. And then right after we do this, I'll tell you what we're going to be doing next month because it's a little bit different. It's going to be an in-person seminar. So Cindy asks, why would an investigator even need to review a personnel file? Cindy, I'll answer that first and we'll see if Marla has anything to add. I think there's a couple of circumstances. It's not often that we review personnel files. If you had some sort of disparate impact claim, you might have to review more than just one personnel file. If there's a situation where maybe somebody has said to you, oh, I think this person has a history of doing this, you might want to see what's been done in the past. I mean, I think your recommendations when you're conducting an investigation and you're making recommendations to the company would differ if this is not the, the wrongdoer's first offense, right? So if they've been warned on multiple occasions, your recommendation to the company or to the client may be at this point termination of employment, as opposed to if this person seems to be an employee in good standing. Otherwise, it might be, okay, so we're going to issue a written warning or get some additional training. Marla, any thoughts on that?
No, I agree. It's particularly important, as Linda said, when you have someone who's been accused more than one time, and you might have, a company that's large enough in size where the first few times the person was accused, the person who's conducting the investigation now or the HR people enforcing now are not the same. So you need to look into that personnel file. Also, it can go to credibility. If you have an accuser who has had issues with supervisors or coworkers or vendors or customers, anybody, of truthfulness, of honesty, they've had issues with that. You want to know that. If they've just been reprimanded many times for performance issues, let's not kid ourselves. Employees often bring these claims right because on the heels of knowing that they're about to be terminated.
Right.
So you definitely want to look at the personnel file. The timing of when you look at the personnel, Linda pointed out correctly, you want to be really careful of, because you don't want to taint, if you're the investigator or whoever your investigator is, wants to be very careful about the timing of looking at the personnel file, because you don't want to taint the investigation too early with, oh, this is a bad person. Because you can have an employee who maybe not on the heels of termination, but has had performance issues, is not performing to expectations, and yet has been the victim of, discrimination. And you don't want the fact that they're not performing well to weigh in on that until the end. So the timing of looking at the personnel file is important.
Right. I think those are really good points, Marla. And also, I would suggest, Cindy, if you're doing an investigation, keep your notes with dates and times on them, so that way if somebody ever questions you and says, well, when did you look at the file, you'll be able to say, I did all of these interviews first, and then I looked at the file right before I wrote my report, or something like that, so you can be clear about the order in which you do everything. Okay, another question from Judy says, would you recommend having the accused write their own statement of events? And if so, before or after the in-person interview? Marla, want to start?
Sure. It kind of depends on how the complaint comes to you. When you first sit down with the accused, I always like to ask them, would you please put this in a chronological writing so that I can put together the plan of investigation? And many won't. They'll say, no, I don't want to. Many say yes, it'll make me feel better. But at the same time, oftentimes they'll just start talking, and you want to take all that information down. Getting it in writing, getting it signed by them, having them review your notes. I think Linda touched on this initially. Your notes to make sure that they're accurate helps so much if in the event it ends up going to litigation and you go to trial. It's not under oath, so it's still something that opposing counsel can attack and say, well, they didn't have legal counsel with them at the time, they were under stress, they didn't understand the question. I mean, there's a lot of ways their attorney can attack it, but at least it is something that has to be attacked because it's there, it's in writing. People tend to believe things that are in writing more than things that are not in writing or created by the opposite side. So that I always like to ask, again, you can't force them to do it.
I think Judy was also asking about the accused, not the accuser, but the accused. Have you ever...
Oh, my apologies. No, I always ask the accused. I don't generally give the accused the written statement from the accuser. I will give them verbally what the accuser has said, and then ask them if they will write a statement as well and provide it. And again, if they won't, then we'll go through it orally, and then we'll go through my notes or the investigator's notes and have them initial. By the way, just in case anyone's curious, most of the investigations that I've been involved in have been done internally by HR, either the HR person who comes into the company like Linda once a month, or the internal HR people, or the CFO who's handling the HR if it's appropriate. I have on occasion used outside PI who are usually retired policemen who have absolutely impeccable investigation skills, and the reason we use them when we bring them, the heavy hitters in, if you will, is we pretty much know that what's going on that's going to go to litigation.
Great, thanks so much for that. Deborah says, do you have any specific training programs you can recommend for employees responsible for conducting investigations? That's a great question, Deborah. I don't know of any. I'm sure, you know, there's the Skill Path group and other people out there that probably offer that. If that's something that you would be interested in, let us know. I mean, Marla and I can probably put something together and offer it as well. Marla, do you know of any programs like that?
I don't, but honestly, I think what Linda gave you this morning as a start is one of the best I've heard. I've probably heard her say it. We probably did this a couple years ago, but if you could really learn what she said this morning, like asking open-ended questions, that's a skill, by the way. And I'm not sure I have that skill. And really listening to what people say, and you know, the newspaper reporter questions, she called them. If you can get really good at that, that will make you a good investigator.
Yeah, and I think it's like anything else. It takes a lot of practice. And so, you know, if I run across something, Deborah, I certainly, you know, can reach out to you. Or like I said, if you want us to put something together for you, we can talk about that as well. I think it's like interviewing in general, which is going to lead me into our final slide in just 1 second. Interviewing in general, it's really hard because when people start out interviewing, they can list out all of their questions, but it almost doesn't matter what the answer to question A is. They're going to go to question B. Whereas people that have been doing interviews for a long time, we know how to follow the path. We know how we can circle back if we miss something, but we'll just follow the conversation wherever it goes, right? Because you never know what an employee is going to say or where the story is going to go. And yeah, I don't want their whole life history, and I don't want them bringing in all of this irrelevant stuff, but sometimes it helps paint a better picture for me to understand that employee and understand sort of their model of the world and what's going on. So that is all the time we have, so I apologize if I didn't get to your question. Want you to know that if you need help conducting investigations, or maybe you want some training like Deborah does, please reach out to one of us. Our emails are right here, and we're always happy to help you with that. Next month, instead of doing a webinar, we are going to continue sort of, this will be the third in our series of seminars that we've done. We have them at Marla's office. It's in the first floor conference room. And this one's going to be on how you can avoid workers' comp claims and costs by some pre-placement steps you can take. So we're going to look at some things like, you know, physicals and drug tests, but our Director of Recruiting, Kimberly Scott, and I are going to give you some questions that you can ask, talk to you about questions you can and cannot ask during that process, but give you some questions that are designed to sort of understand the employee's sensitivity to safety, let's put it that way. And then Marla is going to talk about what types of information you can gather in making your hiring decisions and what you can and cannot use toward that end goal. So that's going to be May 18th. So that's just in probably 3 or 4 weeks. It is a lunch meeting. We bring in box lunches for everybody. So if you can join us, by all means register, and I've given you the link there. And both Marla and I will be sending out emails to everybody on our list to remind you of that as well. So on behalf of Marla and myself, I'd like to thank all of you for joining us. Again, please feel free to contact either one of us with any questions you may have. If we didn't get your question, or if you have any follow-up questions, that's fine. We appreciate your time today and look forward to providing you with more useful information in the future. Have a great rest of the day.